being a landlord is about to get harder. The Renters' Rights Bill is on track to receive royal assent this summer. And when it does, well, the rules of the game are going to change fast. So in this video, I'm going to share with you 5 things that are going to become illegal or no longer allowed once this law passes. Make sure you do stick around because I'm going to be sharing with you some critical information, but also what you can do as a landlord to protect yourself. Stay tuned. Let me share with you Harry's story. So Harry is a buy-to-let landlord in London. He owns 3 properties. Now when his properties become available, he gets valuations from a couple of agents. Usually they give them bottom price and top price. So this example, it's 3.5 grand to 4 grand. Now Harry likes to go on the bottom end because he likes to get demand for his property. He gets 5-10 people through the door and they usually get around about 3,750, closer to £4,000. Harry picks the best possible tenant, not only in terms of the offer, but also in terms of financial referencing. Fast forward to 2026, and if Harry wants to achieve £4,000, well, he's going to have to put the property on the market for £4,000 because the government with the Renters' Rights Bill is going to bring an end to rental bidding wars, meaning that Harry cannot take or accept a penny more than the advertising price. What's Harry going to do then? Harry doesn't want to feel that he's leaving money on the table, where before he'll put it for 3.5 grand. If he didn't get much demand, then it will be 3.5 grand what he will take. But in this situation, Harry's going to take the top price. And if he needs to adjust the price, if he doesn't get much attention on the property, then that's exactly what Harry will do. Even if the tenant offers the landlord more money, without the landlord asking for a penny more, the landlord cannot accept it. Otherwise, it will be illegal and they may be fined. Whilst the government clarifies that most landlords don't encourage these type of rental bidding wars, it is to crack down on those unscrupulous landlords who make the most of the housing crisis and forcing tenants to bid on their properties. It's well known in the property industry that rental is cyclical, meaning that supply and demand does shift depending on what time of the year it is. Now, typically here in London at least, summer tends to be very busy, and that's for a combination of reasons, but mainly it's because students come in to the city and the country, but also those jobs that are secured by new graduates or just those seasonal professionals shifting that could be at different parts of the world. Now, this of course means that the demand becomes very high, sort of around about June to September. And so landlords and agents are very strategic in making sure that properties are available or come up for renewal around about that period of time. What it means is that they can negotiate with existing tenants if they want to stay. If they don't want to stay, then they find a new tenant. And landlords and agents do this by using the standard short hold tenancy agreements, which are fixed term contracts. And this typically will be 12 months to 24 months, so you can plan ahead. When the Renters' Rights Bill kicks in, there's gonna come to an end. What we're gonna see is moving to assured tenancy agreements, meaning that this is going to be periodic. Now, what does periodic mean? Well, it means a month-to-month tenancy. The tenant can give notice to vacate the property at any time, just given 2 months notice. Now, this sounds scary to a lot of landlords because, again, landlords like predictability. They don't want to be thinking, well, in 2 or 4 months' time, I'm going to have to find another tenant. Well, this is going to be the situation in 2026. And any landlord that wants to force a tenant to actually stay more, well, they're going to be on the wrong side of the law. So in other words, a 3-year tenancy signed in September 2025 would instantly become periodic if the Renters' Rights Bill became effective in October, replacing the fixed term. Now, tenancy reform is one of the government's biggest priorities, and they believe that this move will empower tenants to challenge bad practice without fear of eviction. And despite this, we have lettings data that suggests that tenants prefer to have fixed-term tenancies where they can then renew. In fact, there was a survey and around about 60% said they preferred this method. Only about 30% said that they would prefer periodic. Let's talk about Bill, a buy-to-let landlord in central London. He owns 2 properties. One of these properties is just around the corner from a very prestigious university. So his target market is international students. It has been for the last 15 years and it's worked very well for Bill. Now, what Bill does is he does charge the 6 months to 12 months rent in advance. Why is that? He likes to insure his tenant on his other property, which goes out to professionals. But for this particular property, he can't insure the tenant because the insurance has very strict criteria, including but not limited to financial references, credit history, and so forth. So an international student isn't going to be working. Secondly, because they're not in the country, there's no credit history. For Bill to be able to rent out to that student, Bill charges the 6 months to 12 months in advance to make sure that the tenant can honour the contract. It's a win-win situation for both parties. The government says that when the Rental Rights Bill becomes law, you can only take the maximum of 1 month rent in advance. Anything more will be illegal. And if you're a landlord or tenant watching this and you think I'm getting ahead of myself, feel free to leave me a comment. Let me know what you think is going to happen with the Renters' Rights Bill. Housing Minister Matthew Pennycook stated that the government wanted to bring to an end demands for large rent in advance payments, which he said could sometimes amount to 12 months of rent. Similar in tone, Angela Rayner, the deputy leader of Labour Party, argued that tenants are faced with outrageous upfront costs. And the reality is that this narrative overlooks key facts how most tenancies operate in practice and why landlords legitimately request for 6 to 12 months rent in advance. And some of these reasons vary depending on what type of landlord you are and what type of tenant target audience you have. But right at the top, as you can see from this, is financial security, peace of mind, 56%. And just below is demonstrates ability to pay at 39%. And this starts to trickle down. And right at the bottom, you have upfront payments allowed me to offer a lower than usual rent across the whole tenancy at 18%. And for different reasons, this really gets some landlords fired up. So you're a landlord with a property, you put it on the market, you have a lovely couple, makes an application, and you grant them the tenancy for 12 months. Financial referencing is on point. Now, after 3 to 4 months, the tenants request that they want a pet. Now, let's define the pet. Let's say it's a big 30, 50 kilo Rottweiler, if they exist. Respectfully, the client, you say no. You gave the tenancy and the tenancy very clearly states there is no pets allowed, and so tough luck. That isn't the world that we live in right now. Moving forward in 2026, the tenant will have a right to request a pet. And you as a landlord cannot unreasonably decline that request. Some of these landlords are really spooked. They're saying, well, I don't want pets. Now, again, there could be several reasons for this. One of the biggest reasons is they believe that this will really deteriorate their property and it's going to cost them more when that tenant leaves to get the property ready for the next tenant. Whether that's true or not, I don't know. What can be reasonable in terms of declining? Well, one of those could be that your head lease, if it's an apartment block, then the head lease may not allow pets, and therefore you're going to say, to comply with my head lease, then I'm going to have to refuse. Now, another thing could be if someone's living in a studio flat and it's 250, 300 square feet. Yes, that's very small, and yes, they do exist in London. And they want to have a 30 kilo, 40 kilo Rottweiler. That's not really practical. In that kind of situation, you probably could push back on that. And one thing to be clear about this, it is tenants to request, not applicants. So someone making an application, they can't insist, well, actually I'm bringing my dog or something like that. That is very different from an application to an existing tenant. And if you want to find out the 10 illegal mistakes landlords need to avoid right now in 2025, make sure you watch my next video, also in the description. And now this brings us to what I've concluded to be the major concern for landlords when it comes to the Renters' Rights Bill. Right now, in the current world of rentals, if you have a tenant who hasn't quite breached the contract, but is a total nightmare to deal with, not allowing access to the property, being late with rent, but then paying it so they don't go through the threshold enough for you to take them to court, and so forth and so forth. Right now, you can serve Section 21 and get the tenant out. In 2026 for rentals, that is no longer the case. For you to evict the tenant, you will need to have grounds. Now, there are some fair grounds there, but landlords do like peace of mind. And by the way, I'm not saying that there aren't nightmare landlords as well. Outside of the fixed tenancy, if you're a tenant and you have a nightmare landlord, then at least you have the ability to say, you know what, I don't want to deal with you, Mr. Landlord, I'm going somewhere else. And it's always good for the landlord to also have that ability. And that being said, Grounds for possession include, but not exclusively, to occupying the property yourself as a landlord or family, sale of a dwelling house under rent to buy, sale by mortgage, possession when superior lease ends, possession by superior landlords, and the list goes on and on. It's not to say just because they're abolishing Section 21 is the end of the world for landlords. There are lots of grounds, but of course, there was a peace of mind of having that Section 21. But it also allows peace of mind to the tenant when this kicks in. And the commencement date of the Renters' Rights Bill is going to be more than 2 months after it reaches royal assent and becomes law. So it's going to become effective thereabouts the end of this year, 2025, or dare I say it, at the beginning of 2026. Let's recap these 5 and be a little bit more objective. So number 1, that bidding war. Well, it just means that when you get the top value of the property, that's probably what you're going to go for because you don't want to leave money on the table. Job done. Number 2, the end of fixed term tenancies. What data tells us at the moment is that tenants tend to stay around about 3 to 4 years in their property on average. So I wouldn't be too worried about tenants moving around. If you may get that here or there a couple of times in a period of 10 years where a tenant may stay less than a year, then so be it. That's just the real and new world we're going to come into. The third thing, of course, is the rent in advance. Well, you may have to look at a different target market if that's going to put some more risk to you as a landlord. Or perhaps just figure out what type of other insurance is going to be available. Speak to a professional property expert in your area. And the pets. Well, again, talking about insurance, the insurance is what's going to kick in here, and let's see what available products are going to be out there so that you as a landlord are not going to be at risk from a financial point of view, getting your property ready for the next tenant. And of course, the 5th is the end of Section 21. In my 20 years in property, I haven't seen many Section 21s being served. So this is going to, of course, depend on where your property is located. If you have properties that attract the wrong type of tenants, then that may be something that you want to review from your portfolio and a strategy point of view. But properties generally in very strategic locations that attract the right type of tenants will be the ones that you need to stick with. Make sure you leave me a comment below. Subscribe as we see the Renters' Rights Bill continue to evolve.